but I'm in it. So I'm gonna go over to the room.
Nice to meet everyone again. I think I might have met Roman and Alejandro at the opening.
Yeah. I wasn't able to make that.
I see. Okay, so well, thanks for the invite. And I'm a family law attorney. I've been one for 20 some years. So I've seen my share of litigation, and I don't care for litigation. So Jenny told me that you would like to get an idea as to what happens in litigation. So I decided to compare the different processes. There's the litigation process. That's still the majority of how family law cases are handled. There's the collaborative law that's kind of up and coming, but it can get expensive, and so but it's a lot friendlier way of resolving divorce issues. And then there's the mediation, and so that's what I do mostly. But I still have some cases in the litigation model that I'm trying to just completely transition out of. So I did a comparison of the three processes, and hopefully this will be helpful. So here's an outline that I did, and I'll go through it with you. And I think there's enough copies there. Okay, so what does a litigated divorce look like? So at the initial stage, somebody has to petition the court. So the petition is filed. Inevitably, a response is filed because the two parties are at polar opposites, basically, with regards to whatever issues they have. So the petition, the response, and then there's a stage where one obtains temporary orders regarding custody, timeshare, support, because a divorce usually takes about, I would say about at least a year, sometimes 2 years. And during that time, you need some temporary orders. And so depending on what the issues are, somebody goes in you have to go to court, and you file what's called a request for order regarding these issues. And then there can be a TRO issue. Somebody has a domestic violence issue, so a temporary restraining order is filed. And once that's done, you enter into what's called the discovery stage.
Can I ask a question before we move on? So in that initial petition, somebody goes to the court and they say, I'm filing for divorce, and then the other member of the marriage is then served with papers?
Yes. Yeah, and so the petition and the accompanying documents are served on the other side. You cannot proceed with a divorce without notifying the other side. Yeah.
And so that's when they then respond?
Yes.
Okay.
And they file a response.
That makes sense.
Yeah, and so we have this initial stage, and then during the discovery stage, you do what's called in LA County and in California, financial disclosures. And that basically consists of what's called an income and expense declaration and schedule of assets and debts. And this is required. You cannot get a divorce with bypassing this requirement. And I get requests, people don't like revealing their financial information, and they don't want to reveal, I don't want to, let the other side see what I have, etc. But transparency is key. And in order to come to some kind of an agreement or even court orders regarding financial issues, you have to divulge your financial information. Both sides have to. Yeah, so that is a minimum requirement. During the discovery stage, because there can be all kinds of issues, interrogatories are done, production of documents is done. There can be motion to compel because the other side is not producing what you're asking them to produce. There can be a motion to quash because the other side is seeking information that's too personal to you, maybe like your medical records, and that may not be relevant in the case.
Sorry to interrupt, and pardon my ignorance, and I don't know if this is just me or if you guys also, but I don't actually know what these mean, interrogatories and production.
Okay, so interrogatories is a form of discovery, and it's basically a set of questions.
Okay.
Yeah, so a set of questions that inquire about your work history, where do you live now, some general information. one of the questions is, do you contend not everything in the estate is community, and I may be just assuming things here because you probably don't have a background, of course, in family law, but in California, all the assets that you acquire during the marriage, so from the date of marriage to the date of separation, is considered community property. And that gets split in half, basically. And the same thing with debts. The debts that were incurred during marriage get split in half. There can be wrinkles in that calculation because if you bring assets into the marriage and it wasn't earned during the marriage, but you brought it into the marriage from the beginning, like from an inheritance or your savings, etc., that's a separate property asset. So that doesn't get counted into the community. But to answer Jenny's question, interrogatories are set of questions that's relevant to the case. Same thing with production of documents. You want to see documents that what the other side has, and if the other side is really telling the truth. It's basically corroborating how much money you say you have, or how much debt you say you have incurred. That goes on during the discovery stage. Motion to compel responses. Sometimes people can be difficult and they don't produce what you're asking them to produce. So you have to. The only other way to get the documents is to enlist the assistance of the court. So you go to court, you file a motion to compel. Sometimes they can be a motion to quash. Sometimes you can subpoena records from the bank if the other side, is playing games with you. There can be discovery sanctions, sanctions in the form of you were supposed to produce these anyway, but you didn't, and so I had to go to court. Therefore, pay me the attorney's fees that I incurred. So things like that happen during the discovery stage. There can be child custody visitation issues. In California, the law is really, it's complex. And so if somebody's fighting over custody, and some couples do, the court doesn't know what, the judge has not lived with them, right? The judge doesn't know their day-to-day experiences and what the parties are saying, if that's true or not. So the court appoints an evaluator, a custody evaluator, and the custody evaluator interviews the mom, the dad, maybe the teachers, depending on how old the kids are. If there's therapists involved, the therapist may get interviewed. Maybe not because of the privileges. But the custody evaluator then makes a recommendation to the court, hey, the kids should go and live with mom, or the kids should live with dad, or some combination thereof. And that process takes at least 3 to 4 months, if not longer. And if you engage a private evaluator, not somebody who's appointed by the court, a private evaluator for 730 evaluation can be very expensive. It can be like $10,000 to $15,000, sometimes more. So this is all going on during the discovery stage and during the stage that the couple is trying to figure out the issues. Another aspect could be the financial issues. There could be an allegation that a spouse has hidden money or has gambled some of it or not contributed to the community. And so if there are those issues, then there could be a forensic accountant that gets involved. There could be, and this is two competing forensic accountants, one for one spouse and somebody else for the other spouse. And if you have a cash generating business, a receiver can be appointed. And all of this takes a tremendous amount of time and effort and a lot of money. So you get through the discovery stage, which could last typically a year, sometimes 2 years. And then you get to the pre-trial stage where you get the trial setting conferences. The court makes you go to a settlement conference where the couple sits down with a settlement officer and talks about settlement. It could be voluntary or mandatory. The court may make you to go through mediation because the court really doesn't want to take up, this is, when you try a case, it's so time consuming. And it takes up a lot of resources, county resources. So the court doesn't want you to go to trial. They want you to settle before going to trial. That's like a last resort. So you go through the pre-trial stage, and then if you can't settle it, you go to trial. And the amount of work that's involved in trial, you have the trial brief, the witness list, the exhibit list, the expert witnesses, if you have a forensic accountant, if you have a child custody evaluator who's going to, testify on your behalf. So all of that gets factored into the equation. You have the actual trial. You could be assigned, let's say that you're estimating your trial is going to take 3 days. So the court looks for a courtroom that is available and then sends you to that courtroom. You may get, because there are other cases assigned to that courtroom that day, you may end up with maybe an hour or two, and then the court would reset your date to another day. And so you never get, unless maybe it's a criminal trial, maybe it's a really high profile criminal trial, you may get 2-3 days, consecutive days, but in family law, that doesn't happen very often. So you get half an hour here, maybe 2 hours there, maybe, 3 hours another day. So that's how it gets tried. And then you go through, if somebody doesn't like the judge's orders, then you have the right to an appeal. So that's in a nutshell what it looks like.
That's a lot.
That's a lot.
Sounds terrible.
And it's very expensive. A person can easily spend $100,000. That's, per person. And depends on, of course, the personalities that are involved. And if you have to litigate every little issue, it could take a lot more than that. So that's not the best way to do it, in my opinion. And the best way to do it really is the collaborative divorce.
Lynette, would you say this is the most common way that people do it?
Yes, litigation is still the most common way that people resolve divorce issues because I think it's because that people just don't have the information about collaborative law or about mediation. And you have to file the case to get it started. But not so in collaborative law. So litigated case is the most common way to do it, and then you have improperers who don't have the benefit of being guided through the process. So that creates a lot of backlog, and the judicial officers are really very sensitive, because just because a person doesn't have an attorney doesn't mean that person is not entitled to legal resources, right? So I've seen judicial officers bend over backwards in a courtroom when a person is not represented. So anyway, it's time consuming. And then you have the collaborative divorce, which is the initial stage. I sort of try to do a comparison. You can actually start the case without filing a petition or a response. But you do have to have 2 attorneys, one for each side, who are trained in the collaborative law. And you go through the discovery stage, but it's not contentious. You go through the discovery stage because you are seeking, in order to resolve the financial issues, you need financial documents, the relevant documents, whether it's a bank account or stock account, or you need to know what their value is. And so there is a stage where you're gathering financial information, and oftentimes instead of having 2 financials, one financial for one spouse and the other one for the other spouse, you have a neutral financial. You hire a neutral person because the bank records are not going to lie. All right, so the one neutral financial looks at the bank records and looks at, you know, the stock account and does an analysis. And then you can have one mental health professional if necessary, if there are custody, if there are issues with the children. And you can even hire a divorce coach. And some people do this if they have the means to do it. They do hire a divorce coach, somebody who can take them, talk to them, deal with the emotional issues. And so,
like a doula for divorces.
Yeah, yeah. And so obviously this is not cheap either, the collaborative method, because you hire these professionals. And then during the negotiation stage, the couple and the professionals all sit down at the same table and we discuss how are we going to be able to settle these issues? What are we going to do? What's necessary for spousal support? How much is needed for child support? Where's the money going to come from? What is it going to look like after the divorce? And so we sit down and we talk about these issues. And sometimes these negotiations can get a little heated too, because, you know, everyone in the room, we're human beings, and there are two attorneys who are negotiating for the best interest of their clients. But the collaboratively trained professionals keep in mind that this is a family, and this is not a courtroom where rules of evidence comes in, you know, certain information is kept out for the advantage of your client and at the disadvantage of the other side. We don't play those games in this room. And so it's really a place where we get together to talk about the best way to resolve the issues. And we really do, the collaborative trained professionals are very mindful of how this is going to affect the kids. You know, we're not trained therapists, but during the collaborative trainings that we go through, we are, you know, mindful of certain ways of asking questions or reframing, and we keep that at the top of mind. And then once we go through the negotiations, we do the judgment document preparation stage, where one attorney prepares all the documents that's necessary in obtaining a divorce judgment. The other attorney reviews and then signs off on it, and nobody has to go to court. So this is a really classy way, in my opinion, of doing separation. But it can get expensive, not as expensive as litigation. But it does take, you know, a certain amount of funds to hire these different professionals.
The collaborative divorce sounds so like peaceful and harmonious, but I imagine that's not always how it plays out in practice, because you still have two people who are angry at each other.
Right. And so if there's a divorce coach that can be retained, then that's always helpful. And the divorce coach sits in on the meetings with us while we're negotiating. And of course there can be a neutral, like a mental health professional for the kids as well. But it's not the most popular way to do it at this time. It hasn't caught on just yet because of the expenses that's involved. Yeah.
Sure. Are the clients in these meetings speaking, or are you speaking for your client?
Oh no, the clients are welcome to speak. We sit at a round table generally, and we have the meetings at a point when we have the financial information, because finances is a huge deal when a couple goes through a divorce, because of obvious reasons. You know, you want to because there used to be one household. And now there's going to be two, so how is it going to be paid for? Who's going to pay it? You know, those are very important questions. And then, of course, the kids, where if there are children, where are they going to live primarily, or are we going to split time, or how is that going to look like? Which schools are they going to attend, and transportation issues and all of those things. So we're all sitting together, yeah. And it could be if the issues are really simple, then we could have maybe one meeting lasting 2 to 3 hours. But if there are complex issues that cannot be resolved at one meeting, then we can have a second one or a third one if that's necessary. Yeah.
So this process is maybe just as expensive but shorter time.
Yes. And in the long run, it's probably not as expensive as litigation.
Okay.
Yeah. Litigation is by far, it's harsh. And I've dealt with attorneys, even in the litigation model, we try to be gentle. And if the other attorney's on board, and I've worked with attorneys who are very settlement oriented, which is like you can't ask for somebody better, because that is your goal. And at the end of the day, you really want to settle all these issues so that and put it behind them so that these people can move on. And if you have an attorney on the other side who thinks like that, then you can work together and cooperate and make the process a little less painful. But you don't always end up with an attorney on the other side who's like that. So, when it gets litigious, when it gets unpleasant, then the process can be very long and drawn out.
My impression too is that a lot of people go into divorces with kind of a need to protect themselves. Like, I'm going to protect my assets, I'm going to protect my right to see my kids, or have as much custody of my kids as possible.
Yeah.
And don't necessarily think about the long-term implications of going into a legal battle and how that can affect people emotionally for years and years and years to come.
Yeah. And I want to say that people are catching up. The days are gone when people used to go to court and spend $500,000 on attorney's fees. I mean, that's doable. Some people do that.
Sure.
And I think especially with the millennials, I think millennials are so much smarter, and they're what's the sense in doing that? What is the use? I mean, first of all, they're not having that many kids to begin with, but and I think maybe all of you are millennials, I don't know. but it really doesn't make sense to do that. Yeah. Oh, I see. Okay. Yeah, and some people do end up spending all the equity in the home on attorney's fees.
Yeah.
And
Yeah.
Yeah. I mean, that can be done
I have a question about separation versus divorce. Because I have a client who has separated from their spouse, not legally, but he's starting to make more money now. I mean, he's not officially divorced, and he's like, I don't want to get divorced because it's going to be too expensive. So, I mean, I've referred him to a lawyer almost every session, but he doesn't want to spend the money.
Yeah.
But I'm curious as to, for him, if he wants to keep the money he's making now, is there a difference if you're legally separated versus?
Yes and no. But the law is that everything you make after the date of separation, and that's going to be an issue in your client's case, you get to keep that. That's your separate property, okay? But if he's still living, if a lot of couples continue to live together, even though they have separate lives and they have separate bedrooms that they use, but they continue to live under the same roof, partly because of expenses. And that can, if that's the case, then it can be a little tricky. Yeah, because there's arguments on both sides now.
So the difference is if they're still residing together, not the difference between we're living in two separate places and we haven't filed paperwork for separation versus living in two separate places we have filed paperwork.
The law used to be that even if you're living under the same roof, as long as there's a complete separation, I mean, in complete separation in meaning emotionally, you're no longer, you don't consider yourself to be a couple, you don't have any sexual relations. If that's the case, then you're probably separated. Okay, that used to be the law. But then a new case came down where it just puts all of that into question. And now it's pretty much, unless you're physically separated, then it could come into question,
They're separated. They're in another city.
Okay.
Yeah.
Okay, so there is physical separation.
Yeah.
Then the data, whatever he earns and accumulates from the date of separation, it's his separate property. However, depending on the length of the marriage and what the other spouse is earning, there could be spousal support issues. And if there's children, there could be child support issues. And those
What? Just because you know that doesn't mean you tell the client.
Yeah. And the support, just for for your information, the support that you have to pay is based on your current earnings.
So you're separated.
Yeah.
Basically.
Yeah. So
Interesting stuff.
So the last type of process that you can go through to get through your divorce issues is mediation. And I'm a huge proponent of mediation because it's therapeutic, really, and it's a lot less expensive and it's a lot less time consuming, and there are issues with mediation too. I mean, it's not perfect, and there are hardships. It's nothing is easy, right? But the mediated divorce is when you look at the initial stage, you basically one person files a petition. If all the issues can be agreed upon, then the other person doesn't have to file a response. So that saves money. You don't need temporary orders because couples have a temporary working arrangement regarding custody and timeshare anyway. And so people are a lot more friendly when they're mediating their case. You do have a discovery stage because you have to do the minimum. You have to do the financial disclosures, and but this can be done while going through the mediation process. There are certainly no motions to compel or subpoenas to banks or motions to quash. None of that in mediation. And if the couple is prone, if the couple is litigious, if they really want to go at it, then mediation is not for them. So they wouldn't embark on this process anyway. And then the negotiation stage, you sit down with a mediator and you engage in how the issues are going to be resolved. So it's kind of similar to the collaborative, the meetings that are held in collaborative settings, but you don't have the benefit of having a divorce coach, or, I mean, not that you have to have a divorce coach, not that you have to hire a divorce coach while going through the collaborative process, but you have that option in the collaborative process. In mediation, it's generally, you might have, because of the financial issues, you may, if necessary, you may hire an accountant to go through maybe some, restricted stock issues or some kind of financial issues that may not be worked out without some expert advice. So, but during the negotiation stage, it usually takes about 2 to 6 meetings, I find, lasting 2 hours each. And the mediator sits down with both parties and we discuss how the issues are going to be resolved, what kind of timeshare they're looking at, and the transportation. I mean, all the issues that you would look at in litigated divorce case or in a collaborative setting. But you negotiate all those points, and mediation is very confidential. You can't talk about, if let's say that while going through the mediation process, it doesn't work out and you come to an impasse and you just can't solve it. So you decide, okay, since it's voluntary, you don't have to go through something against your will. So you say, well, I can't do this anymore. We can't resolve these issues in mediation. We have to litigate it. If that happens, then whatever's said in mediation cannot be used in court. Mm-hmm. Yeah, so the mediator cannot be asked to testify in court. And it's generally, it's peaceful and respectful. There's no going back and forth to the courthouse to file a motion, or, oh, she won't let me see the kids for Christmas. And so you go and file a motion. There's none of that in mediation. And then once an agreement is reached, then there's the document preparation stage where attorney mediators generally prepare the paperwork. If it's not an attorney mediator, if it's just a family mediator, then that mediator may not want to prepare the paperwork because you're kind of practicing law at that point. But I prepare all the documents, and then the parties can take those documents and have an independent review by an attorney of their choice. So the fees are very reasonable. It's not cheap, it's nothing is cheap, but it's less expensive than collaborative law, and certainly less expensive than mediation and than litigation. Mm-hmm. Yeah. So I think mediation especially in this day and age, and I think people are becoming more, as a society, I think we're becoming a more collaborative society. And even 5-10 years ago, I didn't really hear the word collaborative a lot, but nowadays I hear it a lot. So I hope that means that we're moving towards a more peaceful society. So yeah, I hope so. So it's becoming more recognized by people. Yeah. Yeah. So anyway, that's in a nutshell. I have a little, I don't know, I guess this is, it's an artist's rendition of what I think looks like comparing the two processes, mediation and litigation. And you're welcome to look at it.
Sorry, you go to the left in a second. Or not.
I have a question.
Yeah.
About prenups.
Yeah.
What's that mean? Is it helpful? Do you recommend it for everyone that gets married?
Maybe not everyone needs it. If you're bringing assets into the marriage, it's not a bad idea, depending on what assets there are. And it depends on, if you own a business, for example, I think it may not be a bad idea to do a prenup. But a prenuptial agreement basically it's going against the California law that says everything you earn from the date of marriage to the date of separation is community property and is subject to equal division. Prenup says, no, we're not going to adhere to that agreement. We're going to say what's mine is mine, what's yours is yours. In the event of a divorce, we walk away with what I have and you walk away with what you have. Yeah.
But if the intention is to protect pre-existing assets, like let's say somebody has an inheritance and doesn't mind sharing money that like they earned from their jobs, for example, but they don't want their inheritance to be touched, California law already protects that, and a prenup isn't necessary, right?
California law does already protect that, but what the problems occur when things get mixed up during marriage.
Right, like if you use that money to buy a house.
Yes. and it started out as an inheritance or started out as a separate property savings account, and then it got put into a purchase of a house, joint, in joint names, and then later it got sold, and then it was used to purchase something else. And so, years down the line, you forget where money came from, and then when you file for a divorce, one person says, well, originally $50,000 of that came from my inheritance. But the other person says, well, but then it's a 15-year marriage, and you commingled it, and it should be split in half. So we have different sense of what's fair. It's not same for everybody, and so that's when problems began. Yeah.
What if you have the inheritance during your marriage?
That's also separate.
Oh, it is?
Yeah,
Because
it's
started
also
before you
separate.
were married, right? Like if my mom passed away when I was married and she left her house to me, the house is part of my pre-existing life, right?
It is your separate property asset because it came from an inheritance.
Right.
However, if it's completely paid off, fine. But then let's say there's a mortgage and you take your earnings and then make the mortgage payments, then the line gets blurry.
Okay.
You're showing a divorce. I think that's everybody's best case scenario.
Yeah.
Well, most of the couples I see.
Well, no, I mean going into a marriage.
Yeah. Which actually brings up a question I had for you. Have you ever seen a couples therapist subpoenaed?
I think I have. Yes. I've never done it myself, but I have heard of, yes, therapists do get subpoenaed. And then you have that privilege.
Yeah.
Yeah. Well, are you subpoenaed?
No, I was just asking.
Oh,
Just
yeah,
because
it
we see a lot of
happens.
couples here, so like,
Yeah, it happens.
And if it happens, we have malpractice insurance that will support you.
Sure.
Yeah.
Sure, of course, I was just
Yeah.
wondering, because it's always there, but I've never heard
Yeah.
of them actually have it.
And then of course, I guess it depends on what it is that they're trying to figure out,
Right.
but you have the waive, you have the confidential, the privilege, and so, and you probably have them sign something,
Sure.
right, at the
Right.
beginning?
Yeah.
Yeah.
And you need both spouses to sign.
To waive
it.
privilege.
Yeah.
Yeah, exactly.
Yeah, so this kind of sort of compares this is something that I had done, and on the left-hand side is the litigation, and then on the right-hand side is mediation, and
I like the
Like the
piece.
people change together.
oh yeah, well,
Over the 2 years.
that's how clients feel. My divorce clients have told me this feels like a big ball and chain that I can't get rid of. And then it compares the active participants in the litigation are basically you're sort of battling it out. Whereas in mediation, you're the parties and a mediator. Attorneys are optional, but attorneys can enter into the picture. The length of process, litigation takes 1 to 2 years. Mediation, we can wrap it up in about 2 months' time. Depends on how quickly the parties are ready to end the relationship emotionally. Yeah, because I find that sometimes one person is ready to move forward, but the other person is not. So we can't force the person who's not ready to hurry up. So you gotta have some patience and you have to wait. But if both parties are on board, then it can be wrapped up in about 2 months' time. Focal points in litigation is law and facts are really, really important. And in mediation, it's parties' needs and interests. And then the cost incurred, there's a huge difference. The decision maker in litigation is judge. The judge decides, whereas in mediation, it's the parties. And it's the parties who drive the agreement. Yeah. So I think it's an excellent opportunity for the parties to sit down And because they get to talk about what their needs are, you know, the let's say the husband makes the money and the husband says, I can only pay, you know, so much money. And the wife says, well, but for the kids need this and that and this, and I need more than what you can afford to pay me. So if that issue ended up in court, the judge would basically do a disomaster calculation and consider the income of the parties, and then gets a, you know, there's a guideline figure. In mediation, I do use that tool, the disomaster calculation, but that's the parties don't have to agree to that number. The parties can, if there's a little bit, you know, room to pay a little bit more, or if the paying party says, there's no way, you know, I can't pay this, then we sit down and talk about it and see if there's some another option. Yeah. And so mediation, in my opinion, coming from a mediator, and I'm partial, so it's a lot friendly, it's more humane.
And I don't think you're biased, you've done both. You've
Yeah,
seen
yeah.
both of these processes from beginning to end.
Yeah.
Yeah.
And as a mediator, I do, you know, keep my biases. I mean, we go through this training, and therapists are mediators. I've seen a lot of therapists work as mediators. Yeah, and so we have to keep our biases in check and all of that. Yeah. Yeah. But yeah, so I have this, and I don't know if I don't know how much time, it's almost 1 o'clock.
We have until 12:10.
Oh, I see.
Yeah, because people have clients that want any time to.
Yeah. Yeah, and so I don't know, can I leave some of these with you?
Yeah,
This is
Wait,
just
what did I say?
12:10.
110?
12:50. Yeah,
12:50.
Oh,
I'm sorry.
12:50.
Yeah.
Thank you.
Yeah.
10 till is what I meant.
So this is like basically it's a brochure about my website. So if you if you have clients who need information,
So,
yeah.
we do.
Awesome. That's fantastic. This is great. This is very thorough.
Do you have any questions?
That was great, thank you.
Yeah, so at least you know that there are these 3 processes that's
Yeah.
out there.
If we have clients who are talking about it or bringing it up and want to know what it would look like, are you the right person to send them to have like an introductory conversation just to?
Sure.
Okay.
Yeah, I would probably, I don't, if they're butting heads, and if they have issues that are litigious, then I probably refer them to an attorney who can, take them through the process. But if they're friendly, then I can probably mediate. Yeah. So to start that conversation to see if I'm the right person, yeah, sure.
Yeah.
I have a lot of clients who are considering post-ups.
Yeah.
Yeah.
Yeah, those are done.
Yeah.
It's pretty common now.
Right. Are you the right person to send them to?
Yeah.
Okay.
Yeah.
Cool.
What's the post up?
It's after you get married.
Then right after you get married.
Right. Yeah. Like let's say you're Jeff Bezos and you realize your business is making a lot of money and you're like, actually, I do want to protect my assets even though I'm already married. Yeah.
Or one spouse has a spending problem. Other spouse,
So you want to protect
yeah.
them against
Or a
it,
gambling problem.
Right,
probably.
right. So post-nups are done. Yeah.
And so the other person has to agree.
Yes.
Yeah.
Post up.
Yes. So in premarital and postmarital agreements, it's a good idea for both parties to be represented, and to know what it is that they're giving up.
Yeah.
Interesting.
Yeah. Yeah. All kinds of fun issues.
Thank you so much.
Thank
Yeah,
you.
you're welcome.
So helpful.
Yeah, it was
Welcome.
very helpful. Thank you.
Good. Good.
Nice to meet you.
Nice
We'll see you